Thank you. It's a real privilege and an honor to be invited here. I want to thank Danny Bogart, who reached out to me almost a year ago and invited me, and to Marissa Cincerolo, who has been a wonderful hostess, and Joel Colbert and Phil Ferguson, who have co-sponsored this, and it's just really an honor to be here. And I want to congratulate Chapman on its 150th anniversary, and what a special occasion and what a privilege it is to be here. It also allows me to be here. My daughter lives in LA, so I get a side benefit of getting to spend some time with her. The federal interstate highway system, as we know it today, was authorized in 1956, and it was only completed in 1992, although the planning began much earlier than 1956. It was President Eisenhower who brought the concept to fruition. He had been influenced by his experiences in the military in 1919 as a young soldier, and later by his leadership experiences during World War II, which made him recognize the importance of having a comprehensive highway system to move troops and supplies. He thought we were going to be talking about education today. Education policy for individuals with disabilities has a parallel roadmap. Both the highway system and the education policy programs recognize the value and importance of connecting separate state and local systems in a comprehensive way. And both incorporate a substantial degree of federal funding, but require state cooperation to implement. Both programs took about 35 years to build, and both are programs that would be difficult, if not impossible, for the private sector or even state governments to carry out themselves. The interstate highway system was intended to connect local and state roadways to a comprehensive federal highway system that would ensure efficient and effective travel from one end of the country to the other. Federal education disability policy attempts to ensure that from birth to entry into the workforce or to independent living, there is an effective set of programs and rights against discrimination that work efficiently and fairly. Today's interstate highways are intersected by spaghetti junctions and sometimes have badly planned on-ramps and poor signage. They often have potholes and are not wide enough in some areas, or maybe even too wide in others. Similarly, the federal system of education for those with disabilities intersects with other education policies such as No Child Left Behind, in the news today, disciplinary policies such as zero tolerance for guns and drugs, school choice programs, desegregation programs intended to provide equality and ensure diversity, and other social programs. Just as it is a good time to review the interstate highway system, education for individuals with disabilities should be revisited by policymakers. Political agendas and resources will certainly affect whether current education disability policy will be overhauled, have its potholes fixed, have its access widened, be provided with better on-ramps and signage, and whether the spaghetti junctions will be improved. My talk today will provide a broad historical overview comparing highway policy and policy for education policy for students with disabilities. I will try to identify some important areas that need attention, areas that I know some of our emerging scholars are already looking at, but I would encourage others to look at as well, and suggest some research topics for those. Let me start with a historical, some historical overview. 1861, starting with 1861, Chapman University was founded as a private, religiously based institution of higher learning. From the outset, Chapman University admitted students of both sexes and all races, certainly very progressive for 1861. Its history and current philosophy highlight its commitment to interdisciplinary study, including connection to professional programming in law and education. And again, I congratulate Chapman on its 150th anniversary. So what else was going on in 1861? Chapman University was founded, of course, and that was also the year the Civil War began. That's the Battle of Fort Sumter, if you didn't recognize it. There was no highway system. Roads were basically in disarray, and public education was only available to a few people, usually only those with money. Let's look first at the history of the highway system. Starting in 1861, there was no nationwide highway system. The nation wasn't even completed. In 1861, there were only 34 states, my home state, Kansas, became a state in 1861. While there were a number of territories that would later be divided into states, most of the nation consisted of states in the eastern part of the continent, plus California, which had become a state in 1850, and Oregon. Even in the eastern part of the continent, there was no comprehensive system of roadways. In part, this was because the primary means of transportation in 1861 was by water, which accounts for the importance of cities like Louisville, where I live today, during the Civil War. Well, I didn't live there during the Civil War, but. In the later part of the 19th century, as railroads evolved, water transportation diminished in importance. Roads were important for transportation, primarily using horsepower, and they played a key role during the Civil War, as we know from the 1863 Battle of Gettysburg, where several key roads intersected. By the early 20th century, we start seeing how the importance of roads evolved. The plan for a nationwide highway system began in 1921, and when the federal government prepared a list of roads needed for national defense purposes. The invention of the automobile was, of course, a second major factor to the growth of transportation by road. Early on, however, it was not apparent whether automobiles would catch on. Ironically, according to one authority, this was especially true in California. With the Henry Ford creation of the production line for auto manufacturing, the Model T became more accessible, not just for the wealthy, and eventually the need for a highway system would be apparent. So instead of build it, they will come, they came, and so we needed to build it. The Federal Aid Highway Act of 1925 responded to both the demand for transportation by automobile and national defense concerns. It standardized road numbering. California was one of the big holdouts for renumbering, so that independent streak, and it took longest to renumber its U.S. highway designations. In addition to the useful numbering system, by the 1930s, federal policy also envisioned the creation of a comprehensive freeway and expressway system. The construction project was begun, but it didn't really take on significant growth until 1956. And why was that? Well, the obvious reason is by the building of the envisioned highway system was stopped due to in significant part to the redirection of labor and materials into the war effort, which slowed down both auto production and road building. So that brings us to the 1950s. From the 1950s to 2011, the plan envisioned in 1921 was finally carried out. After the war ended, the plan resumed. The 1956 Federal Aid Highway Act authorized the interstate highway system as we know it today. The system, as originally planned, was completed with the opening of I-70. And you're going to see on the maps I-70, which comes across to this area of the country, but it was completed in 1992 through the Glenwood Canyon in Colorado, about 35 years after the first construction on the new system began, so from 1956 to 1992. My home state of Kansas was the first project completed, making I-70 the first and last highway worked on. Although, ironically, I have found stories, and I was doing some research, that Missouri claimed to be the first state where it began. And so Kansas and Missouri have had a long-standing feud on many things, including who was the first, but I'm going with Kansas. And this is a picture of I-24 in Kansas, and actually I-24 goes through my hometown. Perhaps it was because people wanted to get through Kansas quickly that Kansas was the first, or at least tied for first state, to construct the highway. Or perhaps it was because President Eisenhower grew up in Abilene, Kansas, which is on I-70. This new interstate, I-70, rerouted much interstate traffic from US 24, much to the chagrin of small towns like mine, and others farther north. Perhaps I-70 in Kansas was first because it made sense to begin construction in the middle of the country, where there were perhaps fewer difficulties in getting easements and rights-of-way. The advantages of the interstate system were that one was not slowed down by those small towns, and you never had to get off if you had an unlimited fuel supply. Additional benefits of the interstate highway system included military troop mobility and other uses for defense strategy. It's also useful for evacuations during disaster, and we've had, unfortunately, too many of those lately. So this brings us to 2011. you recognize that. That's Highway 405. So what's the status of the interstate system in 2011? Actually, that isn't 405. It's a different highway, but I couldn't find an image of 405 that was in the public domain. So not surprising, but it looks crowded. So that is like 405. Not surprisingly, there's a significant need for new roads and repairs to existing roads, as well as a need to widen interstates to allow for the increase in traffic. LA's Highway 405 and the famous Carmageddon highlight this increase. The major obstacle, in addition to the obvious logistical challenges of shutting down a major freeway for improvements, is funding. And the major challenge to getting funding is a combination of the current economic recession and the challenge of getting Congress to focus on anything. Well, I guess they focus, they just don't do anything about it, as the July-August debt ceiling debates demonstrate. So what is the relationship of this overview and history of the federal highway system to federal policy on education for individuals with disabilities? The next portion of my presentation will talk about that. So let's go back to 1861 and education. In 1861, there was no comprehensive public education system for anyone in America, much less for those with special education needs. Often, education primarily consisted of homeschooling, in some cases self-taught, as we see in this picture of Abraham Lincoln, self-homeschooling. In the United States, public education has always been and remains primarily the responsibility of state and local school systems. The role of state governments in education is significant and primary. Before 1861, education, even public education, was only available to wealthy individuals. The concept of a free public education at the elementary school level, which included compulsory attendance laws in many states, evolved by the end of the 20th century. In 1861, for students with disabilities, there was very little, if any, opportunity for education. The rare exception was the existence of separate special schools, such as the Perkins School for the Blind, which was founded in 1829, and the Wright-Humason School for the Deaf, both attended by Helen Keller. There was no generally available education to all children, and it was almost certainly because of the financial ability and status of the Keller family that Helen Keller received any education at all. You recognize that? Yeah, okay. We see the beginning of federal, during this era, the beginning, or early on, the beginning of federal support for higher education. The Morrill Act funded public colleges and universities, which also allowed for increased research by scholars and students in public colleges and universities. And much of that research enabled us to learn what we know today about special education and psychology and so on. An example of one of these schools is pictured here, the University of Kansas, my alma mater. It was seen in 1861 and today. You can see there's been a little change in the 150-some years. The federally funded research, in turn, became part of the changing the basic attitudes and policies toward education generally and special education in particular. Compulsory education by 1918 was required in virtually every state, at least for students without disabilities. Students with disabilities didn't have compulsory education. An interesting sidelight was initially the Catholic school was opposed to compulsory education, and that was the reason they established many of the private Catholic schools. The other thing that happened in this time period is, in the early part of the 20th century, was the expansion of public education at the high school level. And compulsory education then also increased to age 16 in most states. And there is the ongoing discussion within states now about raising the age and so on. Free public education to all age-eligible students at the college level did not become part of the state education systems. And although that is a topic of debate today, the sense is that we should have public education available in the higher ed, but the funding is of course, the challenge. There was a dramatic increase in the number of students enrolling in college during this time period. There's an error. This is the mid-1990s. It was really the mid-1900s. It should be on the slide. But it was during that era where we saw the increase in education for children with disabilities. So it was increased, but it was generally in separate settings, and the underlying basis was removing stress on the child. Eventually, diluted academic training and training for manual work was provided, but still in separate, segregated settings. The philosophy was to avoid disruption in the regular classroom, and that was part of it. Many students with disabilities never attended school. Just as the interstate highway system had its beginnings in Kansas, special education also had a beginning of sorts in Kansas. The 1954 Brown versus Board of Education Supreme Court decision struck down separate but equal education for black students in Kansas and 4 other states in their school systems. That decision established that under the 14th Amendment, separate education was inherently unequal because of the stigma attached to separate education and the deprivation of interaction with children of other races. Separate education was also a denial of due process. This principle was then applied in the litigation brought several years later in a number of cases in different states challenging separation of children with disabilities, and in some cases, the complete removal of them from public education. These cases, these early cases were the catalyst for the federal law to support education. And in particular, those of you familiar with this area know that the Park and the Mills cases in decisions in 1971 and 1972, lower court decisions and settlements, addressed that issue. In those decisions, school systems were enjoined from denying education for students with intellectual disabilities, then referred to as mental retardation, and students whose behavior was disruptive, although the behavior was based in disability. Congress recognized that these decisions established that states that provide public education to students, which all do, must provide to students with disabilities as a constitutional matter under the equal protection and due process principles. But Congress determined that it would be extremely helpful to provide federal funding to support the higher costs of special education. And it would also be good policy to provide a system that ensured some consistency in terms of procedure and substance from state to state. So, again, like the highway system that took 35 years, of course you can make these years come out any way you want, but I think it was about 35 years of where we have special policy for students with disabilities, not just K-12, but higher ed. We look at, it began in 1973, but as I'm going to show you in a moment, I don't really think 1973 began it, but nothing much happened as a result of the Rehab Act initially. The major statute, of course, was the Education for All Handicapped Children Act in 1975, which in 1990, the statute was changed to use the disability as the more preferred term. And then finally completing the roadmap were the 1990 American with Disabilities Act, and thank you for voting for that. It was, I think George Bush said that it was the most important legislation during his term. And then also, finally, the 2008 amendments, which are very significant because they clarified the definition of what most people thought was intended back in 1990. So, what are, although I think probably many of you in this room know the key concepts of special education, I'd like to review quickly its principles in a nutshell. Basically, the special education law offers federal funding to states that would follow a specific set of guidelines. These have to ensure a free, appropriate education, individualized for all age-eligible students, and it's to be provided in the least restrictive and appropriate setting. This is known as mainstreaming, though the word mainstreaming doesn't appear anywhere in the statute. It requires states set up a system of child find, and that there would be procedural safeguards and impartial due process, and a review and appellate process. And the procedural protections are key to the effectiveness of this statute. Beginning in 1979, the federal courts have issued opinions devoting substantial attention to clarifying and interpreting what the statutory and regulatory provisions require. When I began my work in disability law was actually in 1979, and at that point in time there were four federally reported cases on any issue relating to disabilities. Today we have not just 4, we have 15 to 20 Supreme Court decisions alone, and hundreds of lower court decisions that have addressed issues of education for students with disabilities or related issues. I want to draw your attention to the map because I'm trying to illustrate the parallel between the highway system and the special education. And the highway system As you recall, it started in the federal highway system started in Kansas, in the middle of the country, for reasons we're not sure of, but that's where it started. And as I pointed out, the special education laws also started in the middle of the age group. In just as any new program, the initial startup year was rocky, and both the highway and education policies would eventually link to both ends, and we'll see how that happens. Just as the on-ramps to I-70 had to be built, or the highway could not be used, outreach, identification, and placement of this large group of students was required. As schools learned how to identify the children and make the placements, the system improved and worked relatively well. So now you see the highway system linking down here to Los Angeles area. This is the I-70 going this way. So this happened for education with the 1973 amendments to the Vocational Rehabilitation Act. Unlike the thoughtful plan for the special education statute, Section 504 of the Rehabilitation Act was a minimalist statute. It prohibited discrimination on the basis of handicap, which was the term used then, by programs receiving federal financial assistance, which included virtually all state public K-12 schools systems and most institutions of higher education, because they received federal research grants and or provided federal student loan support. Now, in the broader area of disability law, I think it's very significant because most private employers, most private places of public accommodation, most programs did not receive federal financial assistance. So the law interpreted, or the cases interpreting, the early cases, 504 really happened in the higher ed context, which I didn't really focus on until a couple of years ago when I wrote a review of Southeastern Community College versus Davis. And I actually think it's a good thing that it didn't cover the whole country and the whole gamut of the world, that higher education was a better place for it to evolve. So what was the significance in 1973 for education? Well, in terms of the college education, initially it was very ineffective in ensuring education for students with disabilities for two major reasons. First of all, no one knew or understood its implications. I mean, when the ADA was passed, there was a big White House signing ceremony. It made national news. When 504 passed, nobody knew anything about it. It just kind of was, first of all, we didn't have the news coverage that we have today, but it was just very little known about it. But the other reason was the students who would have been college age had not had special education. They were not adequately prepared to go to college because they'd not had the benefits of special education. If there are no on-ramps to the highway, you can't get on. This lack of awareness and lack of preparation is why, for me, the sequence of education policy development for K-12 is considered a later development, even though the Rehab Act was passed earlier. Now, the other end of the highway system and the education is adding, so now we've got K-12 in the middle. I-70 was built first. Then we had this segment that was built. And for education, it is the college students. And now we've got this end, which is the 0 to 5. Just as the stretches of the interstate highway system were built over the years and connections to other roads were made, the EAHCA, or the special ed statute, evolved. In 1986, Congress added the infant and toddlers provisions, a new stretch of highway. Children aged 0 to 5 were now covered. This didn't provide services as comprehensively as K-12, but it recognized the benefits and the necessity of a policy that was comprehensive and gave incentives to states to provide programming. Although the state school system could get money for this, another agency could instead, as long as it was coordinated. Similarly, it was recognized that once a child either graduated from high school, so now keep in mind, here you are, you're 0, you're moving along the highway, now you're in the public school system, now you're going to go to college. Well, if you don't know how to get the transition, it's going to be a problem. So when they received maximum age, once a child either graduates from high school or receives the maximum age eligibility, depending on the state, which is usually around 21 or 23, the student would reach a dead end on the highway with no place to go. Federal policies recognize the value of a comprehensive interstate or lifetime protection program. To respond to that, in 1990, the special ed statute was amended to require that schools ensure a transition plan for students age 16. You probably voted on that as well, or earlier if appropriate, so that the student could transition from college, vocational training, employment, or independent living. So just like the signage, you have the signage where you're going to go west and you have to know how to get there. We need signage. The challenge of this comprehensive coverage has been created. So even though there's supposed to be transition plans, there really hasn't been very good communication for transition from high school to college. These transition plans don't prepare students to come to college with the expectations that they come thinking they have the same set of rights, that they're going to get an IEP in college, that the college has the burden to find them, the child find, the college is supposed to pay for their testing and place them in a setting so they can learn. When the legal requirements are that in college, the obligation is the student to make known the disability and to provide and pay for the documentation to justify an accommodation. The signage for these interchanges is not good, and it sets up some crashes as a result. So now we come to 1990 with the passage of the ADA. So we have built these various segments, but now we have a statute that actually covers all of them. The Americans with Disabilities Act covers the span. And although it didn't really add much technically to what was already provided, at least for schools under Section 504, it received much more publicity, and parents began to use the ADA and Section 504 along with the special ed law and more frequently in their challenges in K-12 setting. By 1990, students with disabilities were entering college in significant numbers, and higher education was increasingly faced with challenges in this, ranging from costs of interpreters for deaf students and appropriate reasonable accommodations for students with learning disabilities and related conditions such as ADD and ADHD, and recognizing, and so that was a major change. We also had at this time, the Department of Education had started providing more technical assistance in terms of advice and guidelines and information, and also more teacher training, but perhaps not enough to respond to the high burnout rates for special education teachers. So, what are some of the repair and the road work ahead for special education or students with disabilities? Just as the highways have had to be rebuilt or repaired when a major tragedy occurs, such as an earthquake or a flood or a bridge collapse, and schools and colleges have had to respond to crisis situations, such as the health crisis as HIV in the late 1990s, H1N1 more recently. That kind of issue has made the news a lot because of the movie Contagion, which has suddenly made people remember and be aware of those issues, even though we haven't had something like that happen recently. These health crisis situations required schools and colleges to rethink their existing requirements for students with disabilities within the context of privacy, health safety, and physical safety context of other laws. These situations require an understanding of both disability discrimination law and privacy laws. Another crisis requiring response was the high-risk behavior and concerns about violence in the communities. As a result, both K-12 schools and colleges have revamped and revisited their policies in ways that affect students with disabilities. The privacy requirements under FERPA in response to Virginia Tech have given schools more flexibility in communicating about dangerous behaviors to parents and others in the community. Related to disciplinary issues for the violent students are the general concerns about students with psychological problems, ranging from depression to exam anxiety, to anorexia, to ADD, ADHD, bipolar disorder, and schizophrenia. These students include not only those who are dangerous, but also those who are distressed and disruptive. What are the rights of these students, and what are the obligations to them at the K-12 level or at the higher education level? What is permissible? What is mandated within the context of federal disability education law? and which of these individuals are even disabled under the laws so that they may or may not have rights. So, we've talked about the repairs, but here's some of the issues that I think require some major overhaul. Like major highways that intersect major cities, there are a number of areas where laws intersect with education policy for students with disabilities. As I see it, there are two major areas where I think these intersecting policies are particularly challenging, and these are school choice issues and No Child Left Behind, which in themselves have intersections with each other. Let's take a look at how these spaghetti junctions in federal education policy got to be so snagged up. One major snag is where the special education policy and No Child Left Behind intersect. No Child Left Behind is intended to improve school performance by making schools accountable. Its underlying principles arose out of the school choice era beginning in the 1990s. The 1983 Nation at Risk report warned that public education was threatening our very future as a nation and a people. The responses to the 1983 report included allowing tax credits, providing voucher systems, funding charter schools. One very recent response included the highly acclaimed documentary movie Waiting for Superman, which featured a charter school in Harlem. This movie highlights the urgent need for school reform by showing how all students can learn, but how the public school system in many school districts and states works against that. For some failing schools, this movie validates the need for school choice. But for others, it has reinforced the priority of fixing the existing public school system. School choice includes programs such as homeschooling, neighborhood schools, magnet schools, charter schools, voucher systems, and tax credits. In general, the school choice movement is another response to failing schools. One theory is that if public schools have competition, they'll be better. So far, the success of these various experiments is mixed. While there's some highly successful charter schools, there are also some that have not improved educational quality. Voucher programs often take funds away from schools that need them the most and divert them to other places. Leaving aside the debate about whether such programs are generally successful at improving education, they are generally not positive for students with special needs. School choice options provide an interesting opportunity to experiment with alternative educational programs. This is particularly true for options like charter schools that allow for substantial change in teaching methodology, teaching materials, and curriculum. Such experiments sometimes focus on special needs children and thus benefit at least some students with disabilities. However, current choice programs often operate in a way that is directly or indirectly exclusionary. Such programs are directly exclusionary because of their eligibility requirements, particularly those with, for those with learning or intellectual disabilities. You have to have such and such grades or criteria to get into a charter school, and you just can't get in. Or because the schools don't provide the accommodations to enable a student with a disability to receive an education within that choice option. To the extent that choice programs result in disparately low participation by students with disabilities, these students will be disparately left behind in the regular school, thus violating the mainstreaming goal of special education. So returning to the No Child Left Behind, the federal level has taken an approach of providing carrots and sticks to ensure quality education. In 2001, Congress passed the statute known as No Child Left Behind. Key to its operation is an elaborate system of accountability and requirements to meet performance goals. States that want to receive federal funds under this program are required to comply with the No Child Left Behind mandates. The key principles include having highly qualified teachers, scientifically based instruction, and demonstration of adequate yearly progress. While most education advocates support the general goals of No Child Left Behind, and in fact, President Obama had a press conference this morning about that issue and reiterated that we all support the goals of No Child Left Behind. The problem is the inclusion of special education in these goals has been highly criticized. In particular, the testing measures have been viewed as being negative for education, too much teaching to the test, so that's a general criticism. And it works against special education because it marginalizes special education by emphasizing testing instead of making the IEP the focus, the Individualized Education Program, the focus. It has done so by increasing dropout rates, and not only for special education students, but also for low-achieving, often low-income minority students. The penalty for not meeting the goal includes loss of federal funding, allowing students to transfer to non-failing schools if there is really anywhere to go, closing schools, and reorganizing schools. Now, this morning, President Obama proposed, and I haven't seen the details of what he proposed, that Arne Duncan, the Secretary of Education, would have the authority to issue waivers, because there's been a lot of criticism about how the law has been implemented, and that virtually no state is going to be able to meet the goals by 2014. I think it remains to be seen whether I'm guessing there will be legal challenges to whether that is within the authority of the statute or not, but it does highlight the problem with getting, although there's congressional support, getting Congress to join in together to do anything is challenging these days. To receive the federal funding under No Child Left Behind, the states have to provide highly qualified teachers and meet a number of other requirements. And the students with disabilities, except for a very small percentage, something like 1%, are not exempted. Now, I applaud the goal of that. I think what the concern is that if special education students are exempted from this high performance, then there would be a tendency to move them all into special education, because then we don't have to count them. But the problem is having only 1% of the students count means that schools sometimes, especially in magnet school programs and so on, don't want to take the student with a disability, because that's going to work against their counting. So it has been criticized as being very bad for students with disabilities in that context. And as I said, there's strong bipartisan support to change the law, because the targets are unrealistic, the guidelines too rigid, the implementation is problematic, there's enormous amounts of paperwork that go with it, and it also requires a great deal of time and resources for this elaborate record keeping. Another clash or unmanageable spaghetti junction between No Child Left Behind and special education is the requirement for highly qualified teachers. Rural areas and other less desirable schools face significant challenges, particularly a lack of resources, to attract not only special ed, but regular education teachers needed to meet the goals of proficiency. In addition, the scientifically based instruction requirement of No Child Left Behind mandates that instruction be based on scientifically based research. Currently, most research on effective teaching is based on general groups that did not include special populations and did not demonstrate effectiveness for students with different disabilities. No Child Left Behind also clashes with the philosophy of special education that the program should be individualized for each student. So, as I said, while the accountability goals are positive, the unintended consequences have made this quite negative for the implementation of the special education statute. Now, I want to step back a minute and also add, because this also can create some other spaghetti junctions and challenges, is an additional the end of the 35 years of special education, and how that has created some new interesting challenges. These are found in the final segment of the road, just as the final piece was about 35 years after, of the highway system was about 35 years after 1956. The most recent and perhaps for the moment final piece of disability education was added in 2008. This was the ADA Amendments Act of 2008. Which clarified the definition of who is protected and said it should be a broad one. Now, this was in response to Supreme Court decisions in 2002 that had narrowed the definition so that anyone who was taking mitigating measures, if you were taking medication for epilepsy or for depression, you were not currently disabled. And so Congress, in 2008, said no, that wasn't the intent of the statute, and rebroadened the definition. So the amendments, and we don't have time to go into the detail on those, but today those amendments ensure that students with epilepsy, HIV, diabetes, peanut allergies, asthma, and similar conditions are generally protected by Section 504 of the Rehab Act and by the ADA, because the amendments also apply to the Rehab Act. As a result, these students are likely to be entitled to non-discrimination and reasonable accommodation. It means that the students with a broad range of mental health problems are also likely to be protected. So, have we widened the road? Yes, we've widened the road. We now have this larger group that are included. And while the types of cases that might be brought by individuals might be different, it is a significant opening up of the freeways, or at least if you can find the on-ramp. We know from Carmageddon, widening the highway is not always easy. Sometimes you have to close the highway while you do it, which is in a sense what happened between 2002 and 2008 while Congress worked on amending the statute. But even when you open it up, the highway or the coverage for a broad category can sometimes be major challenges if the on-ramps and speed limits and signage are not part of the widening process. So, I've talked about the 35-year evolution of policy for education for students with disabilities and the intersection of those policies with other major general education policies such as No Child Left Behind, school choice, privacy laws, and others. So where are we today in 2011? While this 35-year policy development has been going on, there's been an economic recession in recent years. Add to that the general public concern about failing schools, particularly urban public schools, and the response of creating school choice options. And finally, our recent example of legislative gridlock over raising the debt ceiling highlights the challenge for making any new policy changes. Just as resource limitations and government paralysis means that lots of bridges and overpasses will go unrepaired in the near future, these same problems make it unlikely that much will happen to make any major fixes with education. Not only that, but even the on-ramps and signage and the potholes may not be fixed. So while it is unlikely in the near future that major federal intervention will occur, and in fact funding reductions seem probable, it's important that advocates and policymakers have some shovel-ready projects ready to go when things improve. And I'm an optimist, things will improve. And in the meantime, there are some potholes that can be fixed without major federal involvement. It's essential that emerging scholars like those here today continue to study these issues and consider interdisciplinary research in evaluating them and offering solutions. As the debt crisis politics this summer played out, the pundits discussed what this all means. There was a substantial voice that when the cuts really have to happen because of the standoff of compromise about entitlement programs and tax increases is unlikely to happen under this special super committee that's supposed to report back soon, we will have to face what gets cut. As Joe Scarborough lamented on Morning Joe in early August, it will probably be roads and schools. My own view is similar to the view of what I think is the massive moderate middle of the country. And this is actually highlighted in the book, and I commend it to you. That Used to Be Us, the Tom Friedman book that just came out. That while we must cut bad and wasteful spending, we cannot cut infrastructure spending. Just as the roads have strengthened our defense system and provided for efficient movement of goods in a way that benefits the economy, and provided for an efficient exit from disaster during hurricanes and other major tragedies, our system of public education is a critical aspect of our infrastructure. We must sustain a program of education for all students, including those with disabilities, for a number of reasons. Without an educated population base, we will certainly have become less competitive in the world economy. My hope is that while we debate the role of government generally and the role of federal government specifically, we have a realistic discussion of the costs and benefits of how government is involved. Government can regulate, it can fund, and it can reward and punish. It can provide expertise. It can do big things like building the Hoover Dam, as Rachel Maddow is often pointing out to us, that no other person or even a big corporation or a wealthy individual, other perhaps than a villain in a James Bond movie, can do. Those who care about these issues must be involved in the public discourse about the trade-offs and changing our long-standing program of public education. Included in that discourse is the value of an almost 4-decade-old federal program of ensuring that students with disabilities have a free, appropriate public education. The program that we have in place needs to be fine-tuned, but it must remain in place, and it must be funded at an appropriate level. Just as there are some big things that intersect with education policy, there are big things that need to be addressed for education. The clarification of who is covered, especially in higher education, is a big thing. I think more resources are needed to carry out these expectations for higher education students with psychological conditions. Access to affordable mental health service is a big thing. Providing funding and a mechanism to encourage college students to seek help and to allow them to maintain privacy for doing things is a big thing. I previously noted some of the problems No Child Left Behind and school choice. These are also big things that need to be rethought. What else needs to be revamped? The basic infrastructure of special education is in place, but more funding is needed for everything from early childhood education, more teacher training, and more funds for teachers. We need to look at how our disciplinary policies are working and how they relate to students with disabilities, and to rethink how they may not be working. It's not just the big things like the spaghetti junctions and structural changes, but we need some potholes. There are plenty of potholes and on-ramps and signage type issues to address in special education. I encourage emerging scholars to look at these as well. One of the issues that I most often see in my work is that students coming into college do not realize that K-12 is different than higher education, that the transition service mandate under IDEA doesn't seem to be effective, and more needs to be done to fix that pothole. And faculty and staff in higher education need more training about the increasing numbers of students with disabilities in higher education. We also, unlike the roads that have been widened to accommodate more traffic on our highways, we need to look at how wide the road is for students with disabilities and whether these students can get on the roads. Are there too many minority students being channeled into special education? Are these students on the right road? And finally, the challenge of ensuring that technology is inclusive, from distance education to requirements by some colleges that students use readers, to websites, classroom PowerPoints, and so on. And so I leave you with some final thoughts. This is my dog, Skip. He is looking into the future. We try to take a positive and proactive role with our dog. He is a rescue dog, so we sometimes have to deal with him proactively. The discussion about the government role, particularly the federal government, is at the core of whether disability education policy will have its spaghetti junctions revamped, its bridges repaired, its highways widened and repaved, or whether there will be just a few potholes that are fixed, or even if that will be done. In my view, once this debate is resolved, which will probably not occur until after the 2012 election, what should be fixed are both big things, like the spaghetti junctions, and the little things, the potholes and on-ramps and signage. For the highway system, we have in place the easements and the basic plan. The same is true for education for students with disabilities. What I would encourage policymakers to do while the political debate about amendments and resources continues is to start working on research and solutions so they're shovel-ready projects that can be done once the debate settles. This audience is comprised of individuals who are interested not just in the result, but how policy allows those results to occur. I encourage you to be positive and proactive in addressing some of these issues, the issues that I've raised today, and to be ready to respond once the dust settles. Do not wait until Congress or your state education agency is going to do this. Start being part of the conversation that influences policymakers through your research, your expertise, and your advocacy skills. I look forward to hearing our panel of emerging scholars and learning of the directions they are taking and the issues that they are exploring. Thank you.